Any mention?
Like to make a mention for item number 6 and 7, my lord. Number 6, my lord, there's some talks of settlement going on. This is a matter, my lord, where I'm supposed to pay some levy to the government. We are having a talk so that, my lord, we can pay the levy in installments. Seek 3 weeks time, my lord. If no settlement arrives, then my lord, I'll argue the matter. My friend is appearing from the other side.
I'll take instructions as well as to the status, my lord.
We'll just have you recorded that compromise part earlier? No.
But I made a mention before. Your lordship had granted me time on that count only. But I don't think so it's recorded as such.
So we'll just say
3 weeks, my lord.
Lordship.
On the prayer of the petition, I'll just adjourn it for 3 weeks. Just 6 you just say after 3 weeks on the request made on behalf of the petition. Okay, list is made after 3 weeks. Yes.
Next week.
Item number 7, my lord. I have certain difficulty today, my lord. Some matters are listed before the division bench, my lord. 3 appeals. I'm just praying for a week's time, my lord.
Next week is fine.
Is it that case?
That matrimonial dispute, my lord.
Lordship.
204.
Okay, this is also after 1 week on the request made on behalf of the petitioner. So, yes.
Much obliged.
Obliged.
May it please your lordship.
Yes.
Lordship, I'd like to make a mention of item number 13, your lordship.
Item number?
13, your lordship. As the conducting counsel, Mr. J. Shilla is out of station, your lordship.
My lord, no objection.
When do you want it?
After 2 weeks, your lordship.
13 2 weeks. That is also the request of the petitioner. Okay. Yes.
Much obliged, lordship.
Please, Lordship, I beg to mention item 8, 9, and 10.
Why so many matters? So these are all connected matters.
My lord, yes. These
The-
3 are connected matters.
The main petition is still pending, part heard in court room number 3, Your Lordship.
These are the same set of counsels are appearing in this.
My lord, yes. I appear for the state, my lord, and my friend
all
here
three
for all the
matters?
private
In
respondents.
all 3 matters, you are
My lord,
appearing all
yes.
3 matters.
All the 3 matters, I appear for the state.
And you are the private respondent in all 3 matters.
Yes, Lordship. No, only two matters, Lordship. I think 2 matters.
Which matters?
Item number 8 and 9.
Are you sure? Be
No, we are
sure.
appearing
Do
for
not
all the
give a
cases.
wrong information.
All the cases. Yeah. My lord, here, Mrs. Sheikh, he's the colleague of Mrs. Sheikh. They appear for all the respondents, my lord, private respondents, because they are the
So you
petition.
have no objection to the
No
prayer?
objection, my lord.
objection.
Because
Okay, sir. This
those
matter
cases,
also?
yeah.
Same order? 2 weeks. Is it 2 weeks? You're asking for 2 weeks?
Yes, Lordship.
2 weeks on the request of the petition. 8, 9, 10. Okay.
Therefore,
Okay.
My please, Your Lordship, I beg to make a mention on part 2 of the hearing list, item number 11, Your Lordship. The senior counsel is indisposed. So, if
I have
this
an
matter-
objection, your lordship.
So when do you want it?
I pray if this matter
2
may be...
weeks. 2 weeks.
This is Mr. Kamal Agarwal.
Yes, Your Lordship.
Your lordship, I have an objection regarding the mention, your lordship.
Okay, just mention has been made on behalf of Mr. K. Agarwal, Learned Senior Counsel, paying for the respondent
Your lordship, the learned DJ has...
to adjourn the matter by 2 weeks on the ground that the senior counsel is not well.
Yes, sir.
The learned counsel for the petitioner has no objection. Prayer allowed, a list after 2 weeks. Yes.
Your lordship, I have no objection with the mention, your lordship. I pray if this matter may be taken up today, your lordship, as the learned DAG has some important submission to make, your lordship.
You are not objecting to the prayer. Then at the same time, or you are objecting
I
to
was
the prayer.
objecting continuously, your lordship.
Okay, we thought you have no. We got it that you do not have objection. So what is to be done?
So, what happened is, all these days the senior counsel was appearing, but he was not on health ground. I'm just asking adjournment, Your Lordship. If this matter can be taken after 2 weeks, because within 2 weeks the heaven will not fall, because they are praying, they are making a submission for stay of the order which was passed in 2023. So, and that was one of the main prayer in the writ petition. So, if that there was no stay, so again they filed misapplication for the stay of that order. So if this matter may be taken after 2 weeks or so, because on health ground, I'm,
Yes,
I'm
what is the,
Just a
see,
small submission is required to be made
if
by the
all
learned
along you
AG,
have
Your
granted
Lordship.
time on your request, then what is the problem?
Your Lordship.
Especially when a mention has been made on the ground of the
Your
you see,
Lordship.
like, ill health of the senior counsel.
Your Lordship, I can understand Your Lordship, but the learned AG has some important submission to meet, Your Lordship.
What is that? You just tell me.
Your Lordship, I'm not in a
You see, like
position.
you cannot expect this court will wait for you. See,
Just a small submission, Your Lordship. I pray if this matter will be taken up today.
we'll just see, Mr. Abraham. We'll just see difficulty. You just wait here. Let the matter be called.
Much obliged, Your Lordship.
You just consult with the court.
So I beg to make a mention for item 12, Lordship. On behalf of Ms. R. Lordship. Not keeping
Item
well.
12.
Yes, Lordship.
Yes. What happened?
Lordship, she is not being well, Lordship.
No objection.
2 weeks on the request made on behalf of the learned, on behalf of the petitioner. On behalf of Miss So and so, Learned Legal Aid Counsel, Vice so and so. Okay. Yes.
Your blessing. Yeah, please, Lordship. Lordship, I beg to mention item 5. Even though an order was passed to file rejoinder, however, we will not be filing any rejoinder. The matter is already fixed for hearing, so it may be heard on the next date, Lordship. Item 5.
This is a matter pending for filing of rejoinder.
Yeah, it was already fixed for hearing. In the meantime, because of certain subsequent developments, direction was given to the state to file an affidavit. Against that affidavit, we prayed to file a rejoinder if necessary, but however, no rejoinder is required, my lord. So the matter may be heard on the next date.
My lord, I'm not.
No, this is what is the last order in this matter.
The last order was for filing rejoinder, lordship. But I'm making a submission that no rejoinder will be required.
Then wait for the matter to come, because we'll have to verify the order sheet.
Very well, lordship.
Yes.
Daily cause list, item number 1.
Daily number 1.
Please, Lordship.
Yes.
Lordship requires some time, Lordship, to file the counter affidavit.
My lord, lordship, as per last order, the petitioner has already prayed for 2 weeks' time to file the counter.
So he is asking for further time.
His further time, my lord. My lord, no objection, because this was the first, this is the second time, perhaps second time.
So there is no objection. Okay, Miss. Mr. Kharkran.
Yes, Lordship.
Mr. R. Kharkran, under counsel for the respondent, please for grant of some more time for filing an objection on behalf of the respondent in the matter. Ms. R. Colony, non-GA, has no objection. Prior allowed, list after
3 weeks, Lordship.
3 weeks.
Lordship.
Supplementary cause list, item number 1.
Yes, it is that yesterday's matter.
My lord.
Yes. Your turn.
Whether her presence will be required, my lord. She is not there.
Miss Sunny?
May I please, Your Lordship?
Yes.
Your Lordship, I'm appearing on behalf of Dr. P. Agarwal.
Yes. So you will be there.
Yes, Your Lordship.
Can you represent her?
The respondents?
Can you represent her? She's a legal aid counsel.
No, yes. No, Your Lordship. I've been instructed that the submissions on our part are complete.
Okay.
The respondents were supposed to make submission today.
Yes. Okay.
And due to the climatic condition, the internet connections are not working here, so P. Agarwal could not be connected.
No, it's okay. If it's okay, you just only if your presence serves the purpose, that is all right. You do not have a problem.
Yes, Your Lordship. Yes, Your Lordship.
Yes, Mr. Guru. That is the argument was very much confined.
Confined, my lord.
To the issue, because this incident was not denied.
My lord.
Occurrence, nothing was denied.
My lord.
The plea taken by the appellant was that the act was committed under extreme poverty. That is probably that is what this could gather from the argument.
Sorry, my lord.
The argument of the appellate was that whatever has been done, it was done under provocation.
Provocation.
And the charges should have been ordered accordingly, and the punishment should have been. So that is what.
My lord, if I may gather yesterday's submission, it was more or less like a mercy petition, my lord. She had considered to the fact that whatever charges have been framed and it has been proved, and that remaining part of the sentence, my lord, may be considered as set off. That was the first submission, my lord.
Is there any law to do that?
My lord, so far as 420, in order to, my lord, exercise power under 428, my lord, first, foremost requirement of the law would be there should be a conviction, my lord. Conviction should be followed, my lord, by sentence. Now, in the sentence, my lord, if there is any confinement during the investigation or the trial in judicial custody,
that is okay. That is principle of set off. You see,
that can be set up.
That is a different thing.
My lord.
There it is not.
No.
So that is what. Whether that submission which was made on behalf of the appellate.
That doesn't hold water.
So that was not. That is not legislative.
Exactly. In fact, if I may, my lord.
Yes. Now, what is your stand so far as their plea that it is given under provocation committed the crime?
My lord, so far as the provocation part is concerned, my lord, the petitioner herein, my lord, made a categorical submission that under 164, my lord, when the confession statement was recorded, my lord, he had confessed. He had confessed in no uncertain term, my lord. However, at the time of examination under 313, my lord, he had partly, my lord, retracted from what was, my lord, stated in 164. Now, in view thereof, my lord, the petitioner's submission was that whether the exculpatory part of it, exculpatory part of the 313 can be desegregated, whether the court can rely on it partly under 313. Because 313 consists of exculpatory as well as inculpatory, my lord.
Now, to be more precise,
my lord,
her argument was that since the under trial court has relied upon statement made under 164, now this statement should have been accepted as of now. It should not be something like that. You accept only in inculpatory part.
Absolutely.
That is what her argument is.
My lord.
And then she says, since the admission of the occurrence on her part has been accepted, the court has taken it forward, then court should have also taken into consideration the situation which was taken into consideration.
However, my lord, there is a limitation to the submission, my lord. Now, my lord, the part of 164, my lord, as per my understanding, my lord, the part of 164 which is retracted under 313 won't hold any water, my lord, unless and until, my lord, something comes out during cross-examination, my lord. In the cross-examination, if there is a, my lord, statement to the effect that my confessional statement under 164, my lord, was false. If that is, my lord, satisfied in the cross-examination, then the next question comes whether the part denial under 313. That part, my information was taken. Nothing has come out during the cross-examination, nor any suggestion was made, my lord. So, in view thereof, my lord, the submission of the petitioner, my lord, doesn't hold any water, my lord. And my lord, the judgment and order needs no interference. That is the only limited, my lord, so far as the this honorable court. That apart, my lord, the statement of the victim and, my lord, the corroboration, my lord, his statement under 161, my lord, and during the chief, my lord, everything is, my lord, more or less same, and it is corroborated by the
Then 161 we cannot see.
my lord. That is true, my lord.
Unless a person is confronted.
Confronted, my lord.
There is a bar in 160.
However, my lord, that apart, the chief of the PWFO, that is the injured here, my lord, it is fully corroborated by the statement of PW1 and 2, who are the, my lord, who were had accompanied this person, my lord. The statement is as such, my lord, 3 of them, they saw the truck, my lord, and 2 of the witnesses, my lord, who had accompanied the injured person, were on the were inspecting the, my lord, the damages of the truck from behind, whereas it was only the injured person who had gone to the driver person, and he was alone with the person, the accused person herein. And my lord, he has clearly stated that he stabbed me, and my lord, that he was bleeding, and he was shouting for help. And PW1 and 2 has categorically stated that, my lord, yes, hearing the sound, we had gone there, and we found that he was holding his belly, and in one occasion, my lord, he was holding the hand of the accused herein, my lord. So, my lord, that apart, my lord, if there is any minor contradiction, my lord, just because chief was taken after more than a year, my lord, so there is bound to be some.
No contradiction has been brought forward.
No contradiction, my lord.
No contradiction. Only thing is that their plea is that he came under provocation. There was no presence of mens.
My lord, now, mens rea, my lord.
Now, in this kind of offense, what importance mens rea will play?
My lord, if I may read, my lord.
If there is a failure on the part of the prosecution to establish any mens rea,
my lord. If I may take your lordship to section 39, my lord.
Section 39 of
IPC. If I may read, my lord.
Yes, please.
Section 39 reads about voluntarily, my lord. A person is said to cause an effect voluntarily when he causes it by means whereby he intended to cause it, or by means which, at the time of employing those means, he knew or had reason to believe to be likely to cause it. So, my lord, here is a case, my lord. The accused person herein, my lord, is wielding a knife, my lord. So, my lord, and
Wielding a knife is self-defense. Now that is, see, this section 39 probably has nothing to do with mens rea, presence of mens rea. Until and unless you make this court understand that. See, causing voluntarily, okay. But then, you see, when force is applied, when you do something under provocation, this may not come under voluntarily, even if it is assumed that you were aware of the fact what this.
Now, my lord, mens rea, my lord, as it is, the law of the land is that, my lord, unless and until the guilt is proven, the person is deemed to be innocent, my lord. Meaning thereby, my lord, mens rea, my lord, unless and until, my lord, that intention, my lord, the intention is there to inflict that injury or to commit that offence, my lord, that intention in the mind of the, my lord, that person, my lord, that intention is mens rea, my lord. So, for instance, my lord, if I may, my lord, for instance, my lord, baby, my lord, child is playing with a loaded gun, my lord. Now, suddenly it fires, my lord, somebody is killed. So, here, my lord, mens rea is absent, my lord.
That is why, see, this will be,
Yeah, but
maybe it will be homicide, but then may not be
yes,
murder.
yes, exactly, my lord. So mens rea is absent here, my lord. The intention is, my lord, it is not there. So in the same way, my lord, in this present scenario, my lord, in this present case, my lord, kindly appreciate, my lord, the accused herein, my lord, he takes out a knife, and my lord, it is not only once, 4 times he has, my lord, and each and every injury is, my lord, fatal to the, my lord. That is
So no person will at least inflict
my lord, more than one
4
injury. Exactly.
steps in self-defense.
Exactly, my lord. Once, twice, that is understood, my lord.
And
Fourth,
more so, there is nothing on record to show the accused had received any kind of injuries.
my lord, yes. So there was no provocation, my lord.
He did not even
My lord,
say
nothing.
that he should have been medically examined after
Exactly,
this and
my
all.
lord.
Nothing was done.
So, my lord. And these 4 injuries, my lord, continuous injuries, and that too in the vital areas, my lord. So his intent was very much there. His knowledge was there, my lord. It's going to fatal, my lord. And therefore, my lord, the submission is, my lord, made by the, my lord, petitioner hearing, my lord, doesn't hold water, and the impugn judgment calls for no interference, my lord. That is my respectful submission.
Yes, definitely, of course. Since many things were not raised,
My lord,
he has
true.
argued only on limited point.
My lord.
So I do not feel then for an appellate court, probably see the examination of the evidence has to be there.
Exactly, my lord.
That is what the
Exactly.
problem
But
is.
she considered she surrendered and raised her hand, my lord, in the beginning.
The appellant has not argued anything right
My lord.
from
Thanks.
whether anything constitute voluntary, sorry, grievous injury or not.
My lord.
307,
Exactly.
friendly, these things, nothing is there.
Exactly, my lord.
And then normally, if there is a plea of self-defense,
My lord.
then the question of attempt to murder will not come.
Exactly, my lord.
You will never try to kill
Exactly.
somebody in self.
Exactly. Nothing came
But
out,
in
my lord.
307 again has not been challenged.
My lord.
Okay.
DPO.
Hearing concluded, judgment reserved.
Daily causeless. Item number 2.
Oblige.
Yes.
Lordship, we've not been able to establish contact with the petitioner.
Could not follow the code.
We've not been able to establish contact with the petitioner, and I pray for
This is
3
pending
weeks
for what?
to file a show cause through the application.
Application of. Okay.
Recalling setting aside to the order dated 16/7/2018.
There's a miscase filed in this, right? Who is the petitioner in this miscase? In this miscellaneous application, who is the petitioner?
I'm the petitioner.
Yes. What is the case about?
Dogma of Soka, the Needy Alkins.
What was the miscellaneous case?
Your Lordship, we have filed an application for recalling and setting aside an order dated 16/7/2018.
What is that order speaks of?
Your Lordship, if I may be allowed to read, Your Lordship, Learned Counsel for respondent number 4 submits that she has lost contact with the client, respondent number 4, therefore has no instructions. That being so, respondent number 4 is set in ex parte, Your Lordship.
So there was an order of ex parte proceeding against you. So you want that order to be recalled. Then you have filed an application. Now it is pending for filing of objection by. Yes, if you do not take objection, then we will allow this petition.
The problem here, Lordship, is that we've not been able so far to establish contacts. We're just praying for 3 weeks'
But
time.
you have asked for time. See, before also, it is not that
Yes.
earlier also 2-3 occasions you have taken time. Now, if you are not interested in filing an objection, why to delay unnecessary the writ petition?
We are interested, Lordship, but that's the only difficulty that we're facing right now. So we're just praying for 3 weeks' time, hoping that this time we'll be able to establish contact with the petitioner.
You are for district council.
Yes, Your Lordship.
You are neither here nor there, so far as this petition is concerned. Okay. Say, MS Manisha appearing for the. This is in the miscase, okay? This order will be in the miscase. Appearing for the opposite parties. Why respondent here? It shouldn't have been. Price for grant of further 3 weeks' time for filing an objection in the matter.
Highly obliged.
The learned counsel for the applicant has no objection. Here, look, list after 3 weeks, and the main right petition also list is matter after 3 weeks. But the writ petition is going ex parte, so you cannot show the name of the counsel for the applicant here. What did you just say? On request made by the parties in the writ petition. List is matter after 3 weeks.
Much obliged. Item number 3.
This one, whenever you call him, give this miscase first. If this miscase has to come in place.
My lord, here, as per the last order, my lord, the state was directed to produce some documents pertaining to, my lord, compensation being, my lord, disbursed to the landowners, my lord.
This is problem, see, Mr. Gurung. These matters are heard in such a way the court does not remember anything.
Right. And today also, my lord, this matter is being conducted by Mr. Khan, and he's on leg, my lord, in the.
It cannot be a reason. You see, once we have more than one court functioning, you have to prepare for this, and you are working in a group.
My lord.
You have always have somebody assisting.
My lord. My lord, here the documents we have received as per my instruction, my lord, it is to be produced, my lord. So it is not with me as of now, my lord. If it can be, it can come up at the bottom of the list, or my lord, then.
No, but then this document was needed for what?
My lord, to ascertain whether land acquisition was award was being disbursed on behalf of the petitioner, whether it was adequate or not. And that is the challenge here, my lord.
The challenge here is that what? They have not received?
They have received, but it is not adequate, my lord. That is as per the first order, my lord. It is reflected there.
So what is the issue here? Whether they have received it under protest or not under protest? Is there anything?
What?
Yes. What is your prayer?
Lordship, as per
You are ready to take up the matter today?
No, Lordship, as per instruction from my senior, after the state respondents has produced the award statement, I'm pretty that this matter be fixed for hearing on the next day.
Could not get this court could not get what you are. Please tell to you. Repeat your submission.
Lordship, as per instruction of my senior, after if the state respondent has produced their statement award, I'm praying that this matter may be fixed for hearing on the next day. We will be ready.
So that is what. When shall we have it? When shall we have it?
After 2 weeks, Lordship.
In the meantime, we'll supply the.
We can say that on the next day you will produce it.
My lord.
Isn't it?
My lord.
That's on the joint request of the parties. List this matter after 2 weeks. The Mr. R. Gurung learned GA submits that the copy of the award statement in this matter will be produced before the court on the next day fixed. That is all right? You can
My
say
lord,
it.
my lord, yes.
Are you sure you have it with you?
My lord, as per my instruction, my lord.
See, that is what you see. If it goes as your statement, then you will be answerable.
My
So
lord,
you want this to be recorded. You do not want it to be recorded.
off the record, my lord.
Hmm?
Off the record, my
You should not. You do not want it to be recorded.
my lord.
What you said, this on the joint case maybe the parties, this is met after 2 weeks. Then you just say, the state shall produce. The state shall produce a copy of the award statement on the next date fix. Instead of saying that Mr. So and so, okay? Yes. Yes. What is the next matter here?
Item 4.
Item number 4.
My lord, here in this case, my lord, the state once again was directed to clarify as to the, my lord, percentage of, my lord, reservation in respect of the
You
special
have not
category.
received any instruction.
No, my lord, till now.
Mr. R. Gurung London GA submits that he is yet to receive any instruction in the matter and prays for grant of some more time.
2 weeks, my lord.
Petitioner has no objection. You're also there, Mr. Abram.
Just assisting this.
Okay. Prayer allowed, list after 2 weeks. 2
Deep,
weeks.
2 weeks, my lord. Deeply obliged.
We'll come back. Wait.
Lordship,
For the
item,
rest of the matters, will be coming back.
Your Lordship, item number 11 may be adjourned for the, I have some personal difficulties. So I have
Item
some
number
other
11, it was told that
It's,
Dr. Majika has, oh, he's there, has some submissions to be made in this matter.
My lord, only difficulty, my lord, it seems that they are seeking adjournment. I have no problem in adjournment, my lord. The only problem is the trial court is pressing
When
hard.
this matter is coming up, your trial court.
It is coming on 4th or 5th of June, my lord. So, my lord, till the next date, if some kind of, because I filed a miscase also for a stay, my lord.
Then we have to pass some order, you see.
Right.
Just wait, let the full count.
hearing. Item number 5.
Please, Your Lordship.
Yes.
Lordship, we had taken some time to file rejoinder. However, after perusal of the affidavit and on instruction, I am praying, my lord, that no rejoinder would be necessary. Praying that the matter may be finally heard on the next date, Lordship.
The learned counsel for the petitioner submits that he just tried it like this. Although the petitioner had taken time for filing a rejoinder affidavit against the affidavit in opposition of the respondent number 4 on earlier occasion, the learned counsel for the petitioner submits that filing of rejoinder may not be necessary in the matter. He submits that the matter can proceed for final hearing.
Lordship, I also have a submission, but on the last time there was a query that whether the affidavit filed by respondent 4 would be sufficient for all the other state respondents 1, 2, and 3. So
Well, we'll rely on that.
We'll see it at the time of hearing. Let us see what happens. There is no judicial order to that effect.
No order.
No.
What is it? The learned counsel's counsel for the in view of the submission and as agreed to by the parties, release this matter after 2 weeks for hearing.
Lordship.
Yes. Yes.
Lordship.
Item number 11.
Lordship, in this case, I was just praying for adjournment, and the ground of opposing my adjournment is that the matter is.
Very unfair. On all our occasion, you have taken time. Now, mention has been made on behalf of the respondent on the ground that the senior counsel is not well. You are opposing.
My lord, I am not opposing the adjournment per se, my lord.
Yes.
But our difficulty, my lord, that learned trial court is pressing us hard, my lord. And if we have to produce that, my lord, the matter will become infructuous. And in fact, we are compelled to file a miscase also, my lord, on 5th April, if Lordship kindly.
What is the miscase and what is the prayer made in it?
My lord, for stay of the impugned order, my lord. At least till the return, till next date, my lord.
The matter is coming up on the 4th or 5th before the trial court. So if that be the case, then let this matter
4th of June
let this matter may come up on Monday, that is on 3rd. We will finally dispose of.
Today is what date?
Today is 28th.
Today is 28. On Monday, that is on 3rd.
Monday.
See, Monday you may be ready for hearing, but then doesn't mean that order you will get the order on the same day. That is the main.
But at least if the order is passed, then we can communicate
But
also.
I think on the last occasion it was the submission of Mr. Agarwal that he doesn't have any objection to this petition, the prayer made in this petition, probably.
I think.
Have you taken instruction, Mr.
I could not even contact also because of network was so bad that we could not contact. We have been trying since morning, but we could not contact also. But still,
till the next date of hearing also, my lord, Lordship kindly sees page 15, my lord.
Okay. You do one thing. You put the miscase. Heard Mr. Heard Dr. N. Mojika. Counsel for the Dr. Mojika appearing with so and so for the petitioner, for the applicant or petitioner. For the petitioner. Or
well, I am petitioner also, the applicant also in this case.
For the petitioner. What do you have used here? It's petitioner.
Applicant.
It will be in the miscase, huh? And also Mr. H. Abraham, Lord Counsel for the respondents. Mr. Abraham submits that he will be needing some time to take instruction insofar as the prayer made in this miscellaneous application. What is the miscase? This will be so and so for the applicant, huh? Or Mr. So and so, along with so and so for the applicant, and also Mr. Abraham for the respondent. Okay. Then you say Mr. Abraham submits that he will be during some time to have instruction with regard to the prayer made in this application. Instruction with regard to the, with regard to the prayer made in this application. You're asking for adjournment for how long?
Till Monday, because the matter is coming up on Tuesday. So let this matter may come up on Monday, because the trial, the matter which is pending before the trial court will come up on
But in the
Tuesday.
morning you were asking for some longer time.
No, because they are opposing the ground. So only Monday.
Yes, it's all right. At least till the returnable day, let the proceeding stay.
Because I've not been instructed because this
See,
is
you see, it is for only one day. The next occasion, you file of your objection.
Your Lordship,
get
what
it
happened that
repeated.
this prior was made even in the med read petition. They did not get a stay. Then subsequently they file a separate misapplication, Your Lordship.
It was not at all taken up. Probably that is what. Was there any notice issued? Any different order sheet in this matter?
We didn't file in this case, the interim prayer was getting the main petition.
There was a.
But I understand the matter can be heard and disposed of, my lord.
That is the initial
My lord. But now in the meantime, what happened, my lord? 3-4 dates we have sought time, and the Lord, so kindly seize the miscase, my lord. The page I've annexed the orders, my lord, the trial court. Page 14, your lordships kindly seize, my lord. In the absence of any stay, the CBI shall comply with the order of this court by next date. Lordships got it.
If your Lordship is inclined to pass
After
on,
that also,
if
my
not
lord.
Monday, also at least Friday, Your Lordship, for hearing this
The CBI is
misapplication.
directed to comply with this order by the next date, my lord. Page 15 also, my lord. Third paragraph.
If not Monday, also Your Lordship, Friday, Your Lordship.
No, but then if it is straight for one day, what is the problem?
No,
Heaven
because
will not fall.
this learners in the council wants to make a submission.
It's
this
okay. Let him make the
No,
submission.
Your
You will have
Lordship,
the opportunity. Kindly understand, this court is not giving any indefinite stay.
But
please appreciate that. Why you are getting so upset about that?
because I just pray because I was not instructed.
You
I
are an
could not-
accused, isn't it, in a criminal proceeding?
Yes,
The
Lordship.
stay goes in your favor only. It's the prosecution is asking for stay.
Stay of the proceeding, then no problem. Stay of the proceeding, yes.
Then what? What else?
Or stay of the
That
proceeding.
is what
it's
the
okay.
prayer has been made.
Oh, yes, Lordship. Stay of the proceeding, yes, Lordship.
The entire proceedings may be stayed, my lord.
Yes, Your
Of course,
Lordship.
we have asked
Otherwise, you see, we cannot stay this order for this thing.
my lord. Yes. For one date, the next date,
Stay of the proceeding, yes.
4th of June, we stayed, my lord.
What is it? Just then paragraph in view of the submission. Post this matter after 2 weeks. In the meanwhile, we do not have to pass any reasoned order at this stage. We will pass a reasoned order later. In the meanwhile, the further proceeding of special CBI case number 4 of 2021 pending before the special judge within bracket CBI Shillong shall remain stayed till the returnable date.
Yes, sir.
You take the instruction on that.
Yes, Your Lordship. I'll
That
do
is
that.
not going against your interest.
No,
So why you are so much restless?
Yes. Highly obliged, Your Lordship.
You take
Short matter,
instruction
we
on
can
this
argue
thing.
on the next date also.
Yes,
Perhaps if this court recollects correctly, there was no objection to this petty prayer.
For staying the
There's a
person.
time. Anyway, this court exactly cannot recollect, but then that was the situation. I don't think accused shall not suffer for that.
Yes.
They should be happy that proceeding is taken
Yes.
on the prayer of the prosecution. Main case also, as prayed for by the parties, disturbed 2 weeks.
Highly obliged, Your Lordship.
Deeply.
Item number 14.